Hello, my name is Claudia. If your dispute cannot be resolved at an early stage, an adjudicator may decide your dispute at a hearing. If it would be expensive for you to travel to the location of the tribunal, the hearing may be by video conference instead of in person. In that case, the tribunal staff will tell you where the video conference will be held, and you will follow the same procedure as an in-person hearing. If you go to a tribunal hearing, the adjudicator will begin by introducing himself or herself when the hearing starts, and ask the parties to introduce themselves. The adjudicator will tell the parties about the rules and procedures the hearing will follow, then ask the parties to make their opening statements. The person who made the complaint or initiated the tribunal hearing will usually go first. The hearing may also be recorded. Your opening statement is your opportunity to briefly describe your case. Tell the adjudicator what decision you would like it to reach and what evidence you will be submitting. You do not actually submit your evidence at this point. You just tell the adjudicator what evidence you will be submitting later in the hearing. Here is an example of an opening statement.
This hearing is about overtime pay that Leanne Tang says she is owed for work she did for Acme Company in 2008.
I will be adjudicating this hearing. My name is Jim Torelli, and you can call me Sir Adjudicator. Would you please introduce yourselves?
Good morning, Sir Adjudicator. My name is Leanne Tang, and I am the complainant in this hearing.
Good morning, Sir Adjudicator. My name is Kevin McBride, and I am the Human Resources Manager for Acme Company, which is Ms. Tang's employer.
Ms. Tang, you can go ahead and make your opening statement. Tell me what this is about.
I am an accounts receivable clerk at Acme Company. My complaint is about the extra hours that I was asked to work during the months of October and November 2008. During those 2 months, I worked 95 extra hours. I submitted my timesheet for the extra hours, but I was not paid for them. My supervisor, Mrs. Monroe, is here today to confirm that she asked me to work those extra hours, and I have my employment contract that says that I am entitled to be paid for extra hours that I work. I am seeking an order from the adjudicator that Acme pay me for the overtime hours that I worked.
You must provide evidence to the adjudicator. Evidence supports the facts of your case. Evidence can be an actual physical object, like a document that you bring to the tribunal hearing to prove your case. You are also giving evidence when you tell the facts about your case to the adjudicator under oath. When you want to put a document into evidence at the tribunal hearing, you should describe the document you are referring to and ask the adjudicator to mark it as an exhibit. You can also request that a document not be entered as an exhibit if you believe it is not relevant to the issue in dispute. You can also call witnesses to give evidence that supports your case. Your witness should be able to provide the adjudicator with direct evidence about your case. In other words, it is best if they have first-hand knowledge of the facts they are telling the adjudicator. If the evidence is not direct, it is hearsay, and while it will usually be accepted as evidence by the adjudicator, it may not be given as much weight. So, for example, it is much better if an eyewitness to an event tells the adjudicator about it rather than someone who heard about the event from someone else. Often, your witnesses cannot be in the hearing room until it is time for them to give evidence. This ensures that their evidence is untainted by hearing your evidence and evidence of the other witnesses. You will have an opportunity to cross-examine the other party and his or her witnesses. The purpose of cross-examination is to ask questions of and get answers from the other party's witness that supports your own case, and to show that the witness's evidence should not be believed or is unreliable. You can object to a question being asked of you or your witness. Next, the other party gives evidence to support his or her case, and you have the right to ask them questions. The adjudicator may ask his or her own questions. This video clip will show you what to do when you introduce evidence to the adjudicator.
Ms. Tang, now that you've been sworn in, you may proceed with your case.
I have been working at Acme Company since May 2004. I am an accounts receivable clerk. My regular hours of employment are Monday to Wednesday from 8:30 until 4:30. I was asked to work overtime during the months of October and November 2008, but I was not paid for the overtime hours. There are two of us who work in the accounts receivable department, Betty Smith and me. Mrs. Smith was away from work on sick leave from August to December 2008, and I wasn't able to keep up with the work during my regular work hours. My supervisor, Amanda Monroe, asked me to work extra hours during those 2 months because we had a lot of unbilled accounts. It was our year end, and the work needed to get done. During those 2 months, I worked 95 extra hours. I submitted my timesheets for the extra hours, but I was only given my usual pay for part-time work. I was told that my extra hours were put into a time bank and I would not get paid right away. But I worked those hours and I want to get paid for them. I did not ask Acme Company to set up a time bank for me. My supervisor, Amanda Monroe, asked me to work those extra hours. I had to hire a babysitter and make special childcare arrangement so I could work the overtime. I would like you to take a look at my timesheets from October and November 2008. Here are copies for you, Mr. McBride. I was not able to get the original timesheets back from Acme Company because they were sent to the payroll company that handles our payroll. I would like the October timesheet marked as Exhibit number 1 and the November timesheet marked as Exhibit number 2. The timesheets show how many hours I worked each month. Here are copies of my pay stubs from October and November 2008. And here are copies for you, Mr. McBride. I would like the October pay stub marked as Exhibit number 3 and the November pay stub marked as Exhibit number 4. You will see that I was paid for 84 hours of work in October instead of the 131 hours that I was entitled to. You will see that I was paid 84 hours of work in November instead of the 132 hours that I was entitled to. Mrs. Monroe told me that I would be paid $15 per hour for overtime, so I am entitled to $1,425 in overtime pay. I would now like to call my witness, Amanda Monroe, who is my supervisor. Mrs. Monroe, you live at 123 Main Street in Kamloops, BC, and are the manager of accounts receivable at Acme Company. Is that correct?
Yes, that is correct.
Here is an example of a leading question. It is the wrong way to ask your own witness questions.
Mrs. Monroe, you asked me to work overtime during October and November 2008 because we were behind in our work, didn't you?
This is the correct way to ask your witness questions.
Mrs. Monroe, could you please tell Sir Adjudicator about our discussion about getting the backlog of work done in October last year?
We have 2 employees who work in the accounts receivable department at the Acme Company, Leanne Tang and Betty Smith. Mrs. Smith got very ill last year and had to take some time off work from August of 2008 until the end of December. During that time, we fell terribly behind, and so I had asked Ms. Tang if she would be able to come and work some overtime to help us get caught up. She was able to do so, and she made arrangements for childcare so that she could come into the office on the days that she doesn't normally work to do overtime. I let her set her own schedule for the overtime hours, and she did manage to help us with the backlog and get it all back on track. I had assumed that she would put the overtime hours on to her timesheet and get paid with it, as that's usually what happens with the employees, and I was quite surprised to hear that she hadn't been paid for that overtime. think it's quite unfair the way that the employees at Acme have been treated, and I really do believe that she should get paid for that overtime work and with interest. This happened to Charlie from the warehouse as well, and he ended up quitting.
The witness has strayed into irrelevant evidence and opinion. The adjudicator will probably interrupt the witness.
Ms. Monroe, please stick to the facts about your discussion with Ms. Tang about overtime work. You have not been asked to state your opinion on what you think the outcome of this hearing should be. You must only answer the questions you've been asked. Mr. McBride, would you like to ask Mrs. Monroe some questions in cross-examination?
Mrs. Monroe, isn't it true that you are a member of the Conservative Party of Canada?
Sir Adjudicator, I object to that question because it has nothing to do with my claim for overtime pay.
I agree with you, Ms. Tang. Mrs. Monroe, you do not have to answer that question.
Mrs. Monroe, are you familiar with the terms of Ms. Tang's employment with Acme Company?
Well, I had assumed that they were the same as all of the other employees in the company with regards to overtime work.
You and the other party will put all your evidence before the adjudicator. You will submit important documents and maybe have witnesses give evidence that supports your case. The final step is to make closing arguments. Your closing argument is very important because it sums up your case and explains why the case should be decided in your favor. The closing argument is sometimes called your submissions or your legal argument. As much as possible, you should prepare your final submissions in advance and make notes during the hearing about other things you want to mention. Here's an example of a closing argument.
Sir Adjudicator, I would like to review the important points about my case. My supervisor, Mrs. Monroe, gave evidence that she asked me to work overtime to get caught up with work while my colleague was on sick leave. At the request of the company, I worked 95 extra hours during October and November 2008. I have never asked my employer to set up a time bank as described in Section 42 of the Employment Standards Act. I submitted my timesheets with the exact number of hours that I worked during October and November 2008, but I wasn't paid for all the hours that I worked. I was not advised by Mrs. Monroe or anyone else that I would not be able to claim overtime pay for that work. I do not want to take vacation time in lieu of overtime pay or be paid later this year. I want to be paid now. I had to hire a babysitter for the extra time that I worked during those months, and I expect to be paid for that work. Section 17 of the BC Employment Standards Act says that I am entitled to receive pay within 8 days after the end of the pay period in which I worked overtime. There is also the case of Scott versus Bright Lights Limited, which was decided by this tribunal in June 2007. The facts of that case were very similar to mine. At the request of his supervisor, Mr. Scott worked 16 hours of overtime during the Christmas holidays, but was denied overtime pay by his employer. This tribunal decided that he was entitled to overtime pay. In my case, I would like you to decide that I am entitled to 95 hours of overtime at a rate of $15 per hour for a total of $1,425. And I would like you to order that I will receive payment within 30 days of your decision.
Remember that you cannot submit new evidence in your closing argument. The adjudicator will not accept new evidence at this stage of the hearing. So, for example, you would not show your pay stubs to the adjudicator when you are making your closing arguments. Those must be submitted when you are making your initial presentation, because that is the proper time to submit all your evidence. The adjudicator may make a decision by giving an oral decision at the end of the hearing and tell you how the matter has been decided. Or the adjudicator may tell you that he or she will make a decision later, and the tribunal registry will mail a written decision to you. If you don't agree with the adjudicator's decision in your case, you can sometimes have the decision reviewed. Some tribunals, such as the WorkSafe BC, have their own internal review process, followed by an appeal to an independent tribunal called the Workers' Compensation Appeal Tribunal. Some tribunals' decisions may be appealed to the courts by a process called judicial review. The fact that you do not agree with the adjudicator's decision is not a reason that entitles you to review by the court. You must show that the adjudicator's process was flawed, or that the adjudicator made an error of law, jurisdiction, or fairness.